this morning. On a side note, this will be my 5th webinar on POPI this week alone. So I'm actually hoping that you guys are getting the best of me because now I'm basically an expert because it's coming out of my ears, my mouth, everything. So welcome, and I'm hoping I'm going to have a good session this morning. I've been looking forward to this one because from all the webinars we've been watching, the articles we've been reading, the Act itself, we all know how you've read the Act, we've been told A, B, and C, but how do we implement that in our business regarding the body corporate or any other community scheme? And that's what we're here to talk about this morning. I'll be showing my screen quickly. Give me a second. Alrighty. So again, the heading for our webinar this morning is, POPI is here, now what? And this morning, what I'd like to, if anything, what we'd like to take from this morning's webinar is, how do we practically implement POPI? How does one take what we've been given and apply it in our business, in our organization, with our trustees and our other community schemes? I'm joined by Advocate Leigh-Anne. We were brought together by Zelinda about 2 weeks ago, also very well versed in POPI. And after I run through my presentation this morning, I'm going to hand it over to him to just chat about, again, the practical implementation of the Act and his thoughts on it as well. All righty. So what I'd like to discuss is a summary of what I've discussed in the past and what everyone should know by now regarding the Act. POPI stands for the Protection of Personal Information Act. The purpose of the Act is the promotion and protection of one's right to privacy. Cut-off date for compliance is the 30th of June 2021. Who is the Act applicable to? It's applicable to any person who processes personal information. The last webinar we discussed, who a person is, what is processing and what is personal information. And this also relates to a community scheme. We've established that the Act is applicable to a body corporate, a homeowners association, a sharebox scheme, or any other community scheme. We established that once you know that the Act is applicable to you, what must you do to comply? There are 8 conditions that the Act prescribes that you have to comply with when you are processing personal information. We also discussed, the importance of compliance and the consequences for a breach of the Act. And the Act makes reference to one receiving a fine of up to 10 million for breach. There's a possibility of 12 months imprisonment, as well as a damages claim by an aggrieved party. And the next question we ask is, what do we do now with all this information? How do I apply it to my organization or to my trustees? Or how do I explain this to them, or what do we do going forward? And that is the purpose of today's webinar. So from what I'd like to take out of this morning's session is, from my point of view, there are 5 practical steps that you can take in ensuring compliance with POPI. I've laid them out here. The information officer, personal information that you hold, security measures you can take, how does it affect direct marketing, and procedures and training that one can take afterwards, prior to 30th of June. We'll start with the information officer, and this is where Zelinda mentioned there's been some new developments that just as early as this morning we received an email from the information regulator via one of our clients. So, we know now that POPI applies to an organization. If we look at the body corporate, what is the next step? So number 1, you have to identify within your company or body corporate an information officer. This is somebody who will be ensuring compliance with the Act and will be held liable should there be any breach of the Act. The information regulator released some guidelines last month advising, who should be the information officer, how do you register them, etc. So from this guidelines, we read that an information officer is the head of an organization.
For our purposes this morning, it could be the building or estate manager, a chairperson, or a trustee. It doesn't not necessarily be a chairperson. It can be any trustee, because as we know, trustees all hold the same, have the same duties and responsibilities. So identify your information officer, and the next step is to register them with the information regulator. So what I've done here, once this, after the session has ended, TVDM will be sending the slides out to all the participants. It's just the links for registration, as well as an email address where you can also register the information officer. So during this week, the online portal for registration of the information officer was opened by the regulator. It's an online form that you complete, and what's happened now is that when we started this whole process, we informed a lot of the clients that, let's say you've got somebody who is a trustee or chairperson at more than one scheme. It's not common. It's very common for a person to own more than one unit in various community schemes that is managed by a managing agent. And this managing agent attempted to then register this person as an information officer for more than one scheme. What happened then was the portal then didn't allow them to do so, and the regulator then came back, because they sent a mail to the regulator, and the regulator advised that you cannot register an information officer for more than one party, which I found strange, because there is no limitation in the Act or the guidelines that the regulator has issued stating otherwise. So myself, along with TVDM and a few of our other learned colleagues, I'll be looking into this further so that we can get down to the bottom of how this is going to work. Because again, it's not common for one person to be a trustee for more than one scheme, or a chairperson. And we'll be able to provide some feedback to our clients thereafter. Besides registering on the portal, the regulator allows for you to register via email. There is a form that you can download on their website that allows you to complete it and submit it to the information regulator via the email address I've posted on this slide. I posted a link to the guidance note on information officers that the regulator posted during April. So you can at leisure go and have a little nighttime read on this guidance note. With this in mind, I'd like to talk about, what is the role of the managing agent in this whole process. Now, we've established that the head of an organization has to be the information officer. And a lot of clients or trustees and body corporates are asking, but why can't the managing agent hold that role? Because, practically speaking, the managing agent is the one that processes the information on a daily basis. They are the ones that, on instruction from the trustees, communicate with owners, send out management reports, send out AGM packs, deal with owners and their queries, etc. So one of my colleagues in Johannesburg, we actually spoke this morning on the phone, and it's if you think about it practically, it's unreasonable to expect a chairperson to hold the role of information officer when they aren't the ones processing the information on a daily basis. This is something that will have to be discussed further with the regulator, but for now, the Act states that it has to be the head of the organization. And with that in mind, I'd like to just mention that the managing agent is the one that gets delegated the responsibilities from an administrative, financial, and compliance perspective. However, the scheme is still ultimately responsible to its members. They delegate those functions to the managing agent. However, they are still the ones responsible in terms of the relevant legislation. That is why, for our purposes this morning, a scheme is the one that processes the personal information and not the managing agent. The responsibility is delegated, but first and foremost, it rests on the scheme. I think in the future, this will be questioned, or at least debated, because practically speaking, again, the body corporate isn't the one that's processing the information every day. It's the managing agent. So hopefully in the next couple of months, myself and TVDM will be able to give some more feedback to you guys, have a few more webinars, so this can be debated more on. So that's step number one. Identify your information officer, register them on the Information Regulators portal or via email. TVDM does offer the service, so if you are stuck, you can contact them for further assistance. The next item on a practical step when dealing with the Act, regarding personal information, as an organization, assess what personal information you hold, how you hold it, and why you hold it. The Act says that in order to collect and process information lawfully in terms of the Act, you need to show that you are acting reasonably and using the information in a manner that doesn't infringe on one's privacy. Now, for the purposes of a body corporate, we collect information to communicate with members, send out the levy statements on a monthly basis, send them other communication, and send them AGM packs for their AGM every year, amongst other things. And what the Act stipulates is that you must also show that you are processing information for a specific purpose, i.e. the functioning of the body corporate, and it only must relate to your business activities and retained for as long as you legitimately need them. So, all this information, once you establish these things, what do you do next? A body corporate's POPI manual will highlight all the above, and that is what the Act requires. POPI states that a person must develop a framework or manual that guides compliance. So you'll prepare this document, and you'll do it yourself, or you'll ask somebody else to prepare it for you. TVDM as well offers the service. You'll ask them to prepare a manual, and you'll give them the information. How do you hold? What information do you collect? How is it retained at your offices? What is the security in place to keep it secure? Another aspect of personal information is a privacy policy. So if your organization has a website, you'll have to have this document as a link and place it on your website. The privacy policy is basically a document that explains how a website or organization will collect, store, protect, and utilize the personal information provided by its users online. A simple example, when I go onto TVDM's website, the website collects the data of my laptop or my device that I'm using. So I need to be able to know that when I go onto TVDM's website, they have this policy showing what information they are collecting of my device, my IP address, how are they protecting it and storing it to ensure the security of the information. So to recap, you will have to establish the personal information that you process, and you will have to, in terms of a POPI manual and a privacy policy, highlight how you keep it, how you store it, and how you share it, etc. If you have any further questions on this, you can contact TVDM, and they will be able to give you further information on this. The next step, security measures that you have to put in place. As a first point of call, I tell clients, sit down with your team in your office and brainstorm all possible vulnerabilities and sort them out. For example, Zelinda always mentions to me, where she used to work, she just walked around the office and did a quick audit of, what's lying around on people's desks. How do they have access to the filing cabinets, the archive room? Do employees have laptops? Do they take it home with them? How is it secured? Is it password protected? The Act doesn't prescribe how you must keep the information secure. It just says that you must secure the personal information. So sit down with your team, assess the security of your server or your online drive, as well as your office. Is there an alarm system? Are there locks in place? Who has access to the information on site or on a technical device, your cell phone, your laptop, your other computers? What's important to note is that once you've established that and you have your POPI manual in place, and 1 July comes, what's going to happen is that if a breach is suspected or an actual breach takes place where information is lost or damaged or there's unauthorized access, a person must then report it as soon as reasonably possible, as soon as you become aware of this breach, to both the information regulator as well as to the person whose the information relates to, the data subject.
a consequence of this is that, your trust relationship between your clients may suffer if you are allowing a breach to take place 1, 2, 3, 4 times a year, as well as it may affect future business that you may potentially take on if they know that you aren't keeping your information secure. The question I've had on this, and I'd like Celinda, if she can add on to this, we had this question in the week where, a lot of the times, how do we know that our managing agent is keeping information secure? Celinda, could you answer this question for us, please?
She was just
if you recall the conversation we had.
So how does the managing agent secure the information? I suppose,
well, how do I as a client know that you are keeping information secure?
So again, I mean, a managing agent first and foremost has a reputation to uphold. So they're not going to be in breach of that. They are also going to be held accountable if your records, do go missing or in breach of POPI. They have their own POPI compliance that they have to have in place as well. So the managing director of the company or the general manager, whoever it might be, is going to be the information officer themselves. So if there is a breach on their part, they're going to be held just as liable, if not probably more so, than the actual body corporates. And I think the most difficult way of managing all of this is simply the access to those records by owners and persons authorized by writing in owners, which I know that you're going to touch on as well. But we've told all the trustees that we've worked with that the managing agent also has to be compliant. So that alone should give you a sense of comfort.
Yeah, and prior to POPI coming about, a lot of you, and I know myself, where I used to stay at a body corporate, and the managing agent was managing the scheme for many years. So up until this point, they have done all that they have to do in terms of protecting data. And if you haven't had a breach in the past, there's no need to worry that something may happen in the future, because we've all been doing this up until this point. What the Act is now just trying to do is make us cognizant that security is important, and we should do all that we can to secure the information that we protect, and so too to our managing agent. A managing agent I dealt with in the week, he said to his clients, "You're welcome to talk to us about security. Pop into our offices, call the managing director or the general manager, ask us how we are keeping the information secure." Because at the end of the day, we are the managing agent, and myself as a managing agent is the one that's dealing with the information every day. So it's just about remaining cognizant and aware that security is important and doing the best you can to secure the information. All right. Next one. This might not really relate to body corporates, but it is an important topic that I've been discussing the last while with a few organizations, and that is direct marketing. So as you all know, we all get emails every day from Net Florist, Faithful to Nature, Take a Lot, ADT, phone calls as well, where they approach us to promote or a service of theirs or a product. And it's irritating because I'm sick of getting all these calls and all these emails. And what the Act has now stated that those companies, before they email us or phone us, they have to get our consent to do so. A lot of the times, client A will sell their book or their database to client B, so that client B can make cold calls, send out mass emails, selling a service or promoting something. The Act now prohibits that. The Act states that any information that I have, I cannot sell to somebody else or let them tap into for the purposes of marketing. Another example is in terms of any WhatsApp or anything else you share out there, you can only do so with someone's consent. And when you're marketing to an existing company or customer, you have to do so in respect of a similar product or service that you are offering. So for a body corporate that has 10,000 owners on a database, they want to send out a mass email in relation to a new service they're offering as part of their managing agency. A lot of managing agents have separate rental or sale of units. They have a separate department, and sometimes they do tap into the database on body corporate or managing agent side. And unfortunately, if no permission was granted in the beginning for them to do so, you cannot now use that information. One must also have an opt-out on their email signature if any that marketing takes place. And potential new customers that you want to market to, you have to get them to their consent to market to them. So it has to be an opt-in basis. It can't be that if I email you and you don't respond to me within 3 days or 48 hours, you're giving us your tacit consent. That isn't permitted anymore. You have to get them to physically, in writing or otherwise, opt in to receive future marketing emails or otherwise from you. All right. And the last one, it's just about training and equipping yourself and your organization and your trustees, whoever, with the information regarding the Act, so that you know now where you stand going forward. You know, in an organization, we've identified and assessed how we collect information, how we store it, and for how long and for what purpose. And you know, going forward, one is much less likely to have a problem with POPI if everyone in the organization understands the Act and how it is applied. You know, this is a very complex topic, the legislation, and there is never a substitute for tailored professional service. Again, I will market TVDM as their, you know, sectional title experts, and they've now taken on the POPI and done the necessary training so they can provide the advice to their clients. With this being said, I would like to introduce Advocate Louis now. I was introduced to him a couple of weeks ago, and he also has a wealth of knowledge with regards to the Act. And if you're online, Louis, and you can unmute yourself so we can discuss this further, and you can give your take on POPI and how it's going to affect us going forward. Louis, are you
there? Can you hear me?
Yes, we can hear you. Thanks, Louis.
I just want to say, first of all, I admire your enthusiasm, having done this now 24/7, dinner, bed and breakfast. You probably do it with your eyes closed, lying on the beach. So maybe it shows that you can choose a better location, but I believe it's raining in Cape Town. It's nice up here. Secondly, thank you to you and Zelinda for incorporating me in this presentation. It's been fantastic meeting you a short while ago. It feels like a lifetime. Rather than presenting, I've done a few myself, but I've listened to lots and learned a lot from you guys, and I really appreciate that. Just a bit of background. Firstly, in my capacity, I'm more of a tourism specialist than a property specialist, but I have been working on POPI since 2012, and I've been working on the CPA since 2004. And how I got connected to these two fantastic ladies is via Mike Addison, who approached me in more or less 2012 to do a road show around the country on the CPA. And since then, I've worked closely with him on various other areas, indemnity, signage, and so on. And it's been a fantastic relationship. And I'm sure same with the ladies on your screen at the moment. So as also you may wonder, where's this business of Louis the lawyer come from? So having told you I specialize in tourism, you can't be too formal and always with a jacket and tie. So the Louis the lawyer is actually a registered trademark, and it emanated from a network group I was with who said you needed an elevator speech. So my 2-second elevator speech tell you who I am and what I do in 2 seconds. So there you go. Yes, so I'm just going to touch on a few points that Leigh-Anne mentioned where I can chip in. First of all, two of the questions that came up, somebody mentioned that they don't have a website, and there's nothing archaic about that, but I think it may be useful and an inexpensive tool to actually get one generated if you are going to be talking about PI and POPI, etc., as you go along. And I agree 100% with Leigh-Anne's suggestion that you brainstorm POPI and for that matter CPA as well with your team, because it's often amazing how much knowledge resides with your people at the coalface, and they are the people often who have to bear the brunt of a disgruntled client or potential client who, for example, has asked for his quote unquote express informed consent, and to try and explain to the client what that is and why they have to do it, failing which they may get nailed by the information regulator. So that's great to involve your team. I'm a big fan of that. So cryptically, just a few of the issues, not necessarily in the same sequence, but information officer, yes, very important. And I think what is important to note is that information officer, and I agree with the bit of gray area now, whether one person can be the IO for a number of companies, but I think that's going to work out. Ultimately, it's going to work that way, I believe, because you have 5 companies where the CEO just doesn't have the time of day for this kind of thing, and where you then collectively, provided they're all within the same stable, may have one information officer who is then appointed as a deputy information officer. There are certain requirements. The information officer has to be an employee, has to be at management level, must understand the company. But at the end of the day, he's the guy who is required to do the training. And he is the guy who can be criminally liable if there's a lack of bona fides or willful wrongfulness and gross negligence. So that's on that point. Then as far as the code of conduct goes, which has been left for me to chat about, it's like most of the things, and you'll see, I will mention later, the DIY element of POPI, and where you actually can do lots yourself or to a degree. The code of conduct, as with the information regulator and with a number of other areas of POPI, has got a very good set of guidelines that have been issued by the information regulator, which not only tells you why you need the code of conduct, but what also should be in the code of conduct. So as I mentioned in one of the other webinars recently, the CPA also required of you to have a code of conduct, and that's now 10 years ago, a bit like the manual, which is now 15 years old, which I'll also touch on. So there's also some possible permutations. Either you can do your own code of conduct, or you can wait for information regulator to issue a generic one, which obviously won't be ideal if you want to make it subjective. Conversely, you can have one with drafted by your association. So the various property bodies that I'm sure you guys are aware of.
If I can interrupt you there, when you refer to the code of conduct, just to keep everyone in the loop, what the regulator has stated that they'll be issuing codes of conduct for different sectors, i.e. the property industry, the food and beverage industry, etc. So that's when he refers to code of conduct, that's what he's talking about. Okay, sorry guys. Yeah, sorry. I'm okay. I think everybody must be close to on your page with the knowledge of the webinars and so on. But yeah, sorry to assume knowledge, as I always say, assume is a dangerous thing. So but I'm a great believer in associations drafting their own, because already, for example, some of the tourism bodies I work with, I know they have their own codes of conduct. So for me, it's a matter of tweaking that code of conduct. And likewise, I'm going to link into what Leigh-Anne said about privacy policy and your PI manual. It's a matter of tweaking what you already have. So a lot of what's on the table to be done is not a matter of starting from scratch, or the classic legal term de novo. You can tweak what you've got. So the next item on my list is exactly that. It's the PI manual. So as I mentioned, it's been on the table for 15 years. But I've got a note here somewhere, but I'll mention it now. The submission of the PI manual, you may recall, if you were around or in business in the early days, they were running around the country, the government body, with the whole issue of having to submit the manual. And there was a whinging, and as I say in Afrikaans, knars van tande and what have you. And the SA Human Rights Commission went around the country, and there were about 4 extensions between 2005 and 2011. And there is currently an extension until the 30th of June for any business with less than 50 employees to submit a manual. So you may as well, as I alluded to earlier, combine your manual for POPI and for PI, because there are lots of manuals that you can probably get through the human rights guys that are more than adequate, and you can tweak it and then just blend the POPI requirements into that manual. I won't bore you with the detail, but it's self-explanatory. So if you go onto the Human Rights Commission website, there's a lot of information to be gleaned there. Going back to my DIY approach. Employees, a lot of companies say employees are the main asset.
sometimes they're not treated as such, but be that as may, you need to update your employment contracts. And I think you did mention RICA, Leigh-Anne. So that's something that was also been around since the good old PI days. And it pertains to monitoring staff communications on various mediums, including social media. So again, in terms of DIY, if you go back to your RICA requirements, and if you haven't, it's crucial that you do that, because you cannot intercept without that compliance. And you can then extend that to the current work from home scenario, where a lot of companies are using various technology guides to assess the productivity of staff at home. And by definition, that has some serious privacy connotations. Therefore, you need to get this on the ball and jacked up right away. And there are various measures that I've read articles on where people are measuring performance by CCTV, keystrokes, and screenshots, and what have you. So it's crucial that you revisit your current employment contracts and have a look at that. And there's some interesting research being done. The Boston Consultancy Group have found that 53% of the people they interviewed want to carry on working from home. But the scary part of the CCTV surveillance is that the Kaspersky Group found that 15% of those working from home prefer to work in the nude. So it could have interesting connotations if you don't have the proper addendum to your employment contract. So then the next one is third-party suppliers, I call it, which for me incorporates any business that you conduct where you've now gathered personal information. And bear in mind that personal information includes business information, like trade secrets and so on. So other different from you may have heard of the GDPR. It's the European version of POPI. That one does not cover legal entities, whereas POPI does cover legal entities. But it's crucial that you understand where you're communicating any information with outsiders, and I'm using the word loosely. You need to ensure that those outsiders have privacy protection in place, and especially overseas. So you need to have proper contracts. So what I've suggested, again, on the DIY basis is, unless you're going to pay some lawyers or some consultants massive fees, it's just virtually impossible to vet all the contracts you have with third parties. So what my suggestion is that you draw up a generic addendum that you attach to all the contracts with third parties. Now, obviously, overseas, it's a problem for you to ascertain whether certain legislation is compliant or better than South Africa's POPI. And you'll be interested to find, for example, like when I was working on the CPA, that already there were 6 countries in Africa that had a CPA in place. So we were a bit of a Johnny-come-lately there. But there is talk that's similar to what has happened in Europe. There was what they call the EU Declaration of Adequate Safeguards, whereby the EU, a controlling body like our information regulator, sussed out international communities and then indicated guidelines of countries where compliance is on a par with POPI, and you could then safely deal with those entities. Also, what needs to be done, you can find guidelines in a mandate that was issued by the GDPR. They have issued what they call the European Data Protection Board. Body there has issued some guidelines. It's EDPB rather. So the acronym there: E for Echo, D for Donkey, P for Peter, B for Bravo. So if you Google that, we'll also give you some good guidelines for compliance. And if you are dealing with European citizens or people who are domiciled in Europe, you need to be au fait with the GDPR. So if you have problems there, Google it. I've actually written an article comparing the GDPR with POPI in 2018 when it came out, and everybody was in a bit of a tiz like they are now. But like most of these things, people have a good drink or two and then the problem goes away. So obviously not quite, but this certainly dissipates the urgency. So then the next one is credit reporting. Just very briefly, if you do certain credit reporting, i.e. assessing people's credibility, letters of reference, especially your staff comes into the loop here, you need to approach the regulator right now to get permission for prior authorization for such processing, even before the 1st of July. So you've got 3 things you need to do ASAP. The one is the information officer, the next is the code of conduct, and the next is the prior authorization. Then I may be talking too fast. I tend to do that, but anyway, if I do, just shout, Leigh-Anne. So the next one is the issue of direct marketing. Now, I'm not going to hog the screen on that one because it's quite a simple one, and she's given you all the guidelines. But you may or may not know that already in the days, good old days, when the CPA came into the fray in 2010, there was in the regulation 4, the times of day when you may approach a data subject. And the data subject is people like you and me, and then companies, but the times they indicate, there's not only the times, because there's certain times for during the week, and then weekends and Saturday and Sunday have different times, but it also excludes or precludes or tells you cannot automate that system. So you probably know when you often come in the office in the morning, depending on how early you start, there's normally a myriad of uninvited emails or various other aspects, either on your phone or on your computer. So that's going to be outlawed. And the other nice thing about POPI is that other than was previously the case with CPA, POPI says that if you want to opt out, that opt-out or that SMS, whether it's R5 or what, doesn't matter, that cost must be for the supplier's account, not for your account. And furthermore, where POPI goes further than CPA is that even if you've given your consent, you must get the opt-out option with every communication. And finally, on direct marketing, you may find some good guidelines by liaising with the Direct Marketing Association. They're very aware of what's going on since the CPA days. So that's a good crowd to hook into. Then again, getting onto my DIY horse, the security that Leigh-Anne discussed. Now, obviously, breaches and all that are crucial. And one of the elements of breaches, and where I often describe my job as being a brand manager as opposed to a lawyer, is the breach of any nature has to first be reported to the information regulator and to the data subject. But it gets worse, and that is that the data, the information regulator may require you to publish that breach. So you can well imagine what kind of damage it can do to your company. And I've got a list, it's probably running into 15 pages already, of data breaches locally and internationally that have occurred the last 6 years. And in the one case, for example, in the UK, a person left a tablet on the train, and on that tablet was all the medical aid information of all the staff of this particular company. And the fine was quite devastating. And while I'm on the issue of fines, if you think 10 million Rand is a fine, I'll give you a wake-up call and may want to close your business. If you're in breach of the GDPR, the fine is 4% of your global revenue, or 20 million euros, whichever is the greater. So think about that one, and non-compliance. So you need to get jacked up. Then, security is the next. Yeah, part of security is just to tell you again, if you look at the section of the Act, I think it's 19, there's a lot of detail. For example, it talks about you don't have to reinvent the wheel. It sets the standard. For example, it says a standard must be generally accepted information practices, or what is particular for your industry. It also said it must be of such a nature that you can prevent any unauthorized access or destruction, must endeavor to identify any foreseeable or internal risks, etc., etc. So you don't have to reinvent the wheel. You can incorporate the aspects of the Act directly into a security policy and guidelines when you deal with any outsiders who come and set up your security. And yesterday's webinar, there was an interesting comment about offshore business. And for example, if you store business in the cloud, that can be deemed to be an offshore business. So there's a whole new scenario coming to the fore there.
Louis, sorry, Louis.
Sorry, guys.
I'm going to interrupt you there. We'd like to leave some time just for some questions and answers.
Okay, I've already been talking very quickly. Just give me 2 seconds here. I quickly want to just one or two things that I. That's why I was incommunicado earlier. I like your idea of the privacy policy addressing a whole lot of things. So you can have the cradle to grave dealing with your privacy information in your privacy policy. So most of the people listening will have a privacy policy. So all you can do is to go and tweak that privacy policy. And then I've got some other issues, but I'm going to hog the stage here on WhatsApp. So if somebody has a question there, creating a framework for compliance, and then finally, the many things you can do on a DIY basis. So thanks for the time, and sorry I've been hogging the stage here.
Thank you so much, Gary.
Yeah, thanks. I think you're very enthusiastic, which is amazing because we need people like you giving us advice, assisting us, because this is a mammoth task for some people. So thank you for willing to assist us, and I'm sure we'll be dealing with you in the future. I just wanted to recap 2 or 3 things you mentioned. So what's important is your manuals on your compliance, and the information officer identifying, registering them. And then you mentioned the addendum to your contracts with third parties. TVDM does offer an addendum that you can use, that companies can use for their clients, as well as you mentioned the fining system by the regulator. One of my colleagues that I mentioned before is in Joburg, he's an attorney. And he said to me that from what he's heard, the fining system will be about 3,000 Rand per incident, or per instance. And he did say to me that if you send a mail to somebody with their name, cell phone number, ID number, and nationality, that's 4 pieces of personal information. So that could ultimately mean that you'll be charged 12,000 Rand fine, because each item is its own piece of personal information. So we need to know how it's going to work, but hopefully in the next couple of months we'll have some case studies that we can present on. Over back to you, Celinda.
Fantastic. Louis, thank you so much. I would have loved for the webinar to be 2 hours long and talk, but unfortunately we do have a time crunch, so thank you so much. Louis, I have shared all of your details on the chat function, your telephone number, your email address, your website, your Twitter handle, as well as your blog. There was a
request, consent, so don't worry.
There was a request that article you mentioned be made available. I tried to have a look for it quickly, but perhaps if you'd like to just share that on the chat function, otherwise I'm happy to send it out afterwards. But I did share it.
Is that the GDPR one?
Yes, yeah.
Okay, yeah, I'll make a note here, and I'll pass it on to you.
Fantastic. All right, we've received a couple of questions. So let's have a look at as many of them as we can. The first one, Leigh-Anne, you'll guide me as to whether or not you or Louis will answer them. Do trustees need to sign confidentiality agreements, or are they covered under fiduciary duty?
So it is a question have been asked before. So under a trustee is guided by, or is mandated to fulfill certain functions in terms of the STSMA and other legislation, and POPI is no different. So whether you are signing a document, further document or not, it doesn't absolve you from complying with POPI or with the STSMA. So there's no need to sign a further document.
In what circumstances can personal information, example CCTV recordings, be given to lawyers and the police?
So this is one of they mentioned this in the Act. So, whenever you're sharing information, you're doing so for a specific purpose. And the Act states that if you are handing over CCTV footage to the police, the purpose there is for national security or whatever the case may be. You are permitted to hand over the footage, and there's no consent is required for that, because it is a specific clause in the Act.
Yes, I can add to that as well, guys. There's a section 6 and 7, rather 6 more particularly, but and also the CCTV. I see there was another question. You can argue that it's used for the prevention and detection of unlawful activity, so that's an exclusion. And there was a court case just last month where personal information was disclosed in a trial in court, and again, that was by virtue of the exceptions allowed.
Thanks, Louis.
Pleasure.
Next question: levy statements sent to owners, would they have to be password protected?
No, like I've mentioned in the previous webinar, whenever you are sharing information, you need to do so or assess that you have a lawful basis to do so. The sharing of levy statements falls within the mandate in terms of the STSMA. You send levy statements to owners because they're an owner of the scheme and they have to pay levies. So there's no consent or any further encryption required. They are entitled to the information by virtue of the fact that they're an owner, and you are both bound by the STSMA.
All right.
Can I just add to that as well? I'm not going to detail it now, but I did send you a WhatsApp, Zelinda, on what to do on WhatsApp to go from the default, which is everyone, as opposed to my contacts. So if you want to share that, that may be quite useful.
Fantastic. I will do so. Thank you very much, Louis. How long can you keep CCTV and biometric details captured at access and egress points?
So it all relates again to purpose. You know, you collect information for a purpose. And once that purpose is no longer there, you have to get rid of the information. With CCTV footage, there is certain guidelines that, you know, industry standards, I think it's either 3 or 6 months. And thereafter, you can then destroy the footage. So just have a look at that. Louis, you want to add to that?
Yeah, I like that. Just to give you an example, I always like asking the guys when I drive in, what you can do with my driver's license, you know, is it on the market or you're going to delete it? But at the school we well know around the corner from our house, they actually use the footage to apprehend criminals. So it was a clear indication of the issue of detecting unlawful activity and linked to that, the period. So I think, as you say, if your purpose is criminal detection, I think 6 months is probably adequate. But then we had a discussion yesterday on a webinar where something came to trial after 6 years, and after 5 years, the information had been deleted. So it's very much a matter of determining whether your processing or further processing has extended its life cycle. And if you can prove that in certain cases, I believe, if you can prove that in certain cases, the extended retention helped you with certain aspects, and you include that in your consent form, you should be okay.
This is actually a question that came up at that meeting yesterday evening, Leigh-Anne, if you can remember, in the 5 hours that it took. Can a list of delinquent owners or non-payers be provided at the AGM to other owners in the scheme? I suppose you can answer that from an HOA and a body corporate perspective.
Just repeat that again, Zelinda.
Can a list of delinquent owners or non-payers, levy payers, be provided at the AGM to other owners in the scheme? So obviously annual financial statements and reporting.
Yeah. So this comes down to your lawful basis. Whenever you are sharing information, you always have to look at what is empowering you to do so. For body corporate, the STSMA states that defaulting owners must be listed in the financial statements. And for an HOA, always refer back to your constitution or your memorandum of incorporation if it allows you to do so. If not, then you have no lawful basis. But from a body corporate point of view, it does state that you must supply the information on the financial statements. So yes, they are permitted to do so.
Louis, if you could help us out with this one. Regarding clients and members already on WhatsApps or data that's kept outside the Republic, for example, Dropbox, must we retrospectively get their written consent or notice, or only going forward as from the 1st of July 2021?
Yeah, that's that distinction between new and existing customers. I had that question. We did a SATSA webinar about 2 weeks ago, and the same question came up. And I believe that with existing customers, you still have to get information. And the CPA was actually quite categorical about that. So it's not a new thing. That's been around since 2010. And the CPA already then determined that you need to get a consent from, even if you had a client that can't just start bombing them, you need a consent. And this is something else which I meant to mention. The CPA came out in 2010, 1st of April, no April Fool's joke there, but that same day the regulations were issued, and it changed quite a few things like fixed term contracts impacting on gyms. And so don't be surprised if simultaneously with on the 1st of July, with POPI becoming law as a whole, that there will be regulations that will be quite sweeping and may address some of the issues we discussed today.
Fantastic. Louis, this one's most certainly for you, not only from a POPI and PIE perspective, but from, I know, your lifeblood, your interest. Is a disclaimer board indicating detail being recorded and captured sufficient at the access gate at an estate?
Well, yes and no. One of the points I made in one of the webinars is that they talk about plain language. And that's in section and CPA in section 41. And I gave the example of walking into the ICC in Cape Town, and where you probably need a day to read the notice if you had good eyes. So I think it's good to have a succinct, bold signage which deals with COVID, indemnity in general, and privacy. But you need to link that to a website. And I would add to that ideally you have a book they sign, because you need consent to private information, personal information being captured. And the Act talks about assent, or the CPA talks about assent. But it's very difficult to prove, did the guy nod, and was he, or did he have a physical problem? That's why he seemed to be nodding like a dog in the back window. Or so it's better to get the written consent acknowledgement. And I would suggest that you combine training of the security staff with cameras, with a book, with the signage.
Fantastic. Leigh-Anne, I'm going to hand this one to you, because I'm sure this is not only my life goal, but your life goal as well. If owners need access to the camera in the elevator as the elevator door opens into their apartment, how do we go about allowing owners this permission?
Well, that's a tricky one. Look, CCTV, the purpose of CCTV footage is for security purposes. So the minute that it's, storing footage of an owner's apartment, it's inside their apartment, and if that is now also forms under the definition of personal information. Any data you're collecting of an owner, you try and be. It's always about being as invasive as possible. So if you're collecting that data, they have to be informed. And again, it's about what you're doing with the information thereafter, storing it. And if the purpose, if you don't require the person's footage of their flat, then you haven't got a purpose to keep it, thus it must be destroyed.
This question came up quite a few times, and I know that you did deal with it during the course, and you and Louis can obviously answer it, is what happens if the chairperson of a scheme does not want to be the information officer? And I'll extend that to say, what happens if the trustees don't want to be the information officer?
The guidelines released by the information regulator during April stated that, by virtue of your position, you're automatically the information officer. Yeah. So there's no hiding away from it. If you still refuse to do so, you can appoint a professional trustee to fulfill that role. Again, it doesn't have to always be the chairperson, but if nobody wants to fulfill that function or be appointed, it's automatic. Otherwise, it's best that you appoint a professional trustee to tackle that role and be registered as such.
I agree. The Privacy Act links to PI, and PI is quite explicit about that. So, yeah. So yes, 100%.
I just had a scary thought, and it just hit me. I can't believe it. I just thought about it. Is that I'm a professional trustee and chairperson in 2 schemes. So I think my rate is going up. That leads me to a question that is probably more sectional title than it is POPI or PIA, but somebody asked, if the trustees have to take on this responsibility, surely they should be able to charge for it. What is your view on that, both of you?
Well, I think it's a more moral, ethical issue than a logistic, a statutory issue. I don't think there's anything in the statute that precludes you for charging for it, but then you may find people who are quite happy to do the job without getting paid. So.
Yeah, and trustees don't. You do this job, and that's the the problem we face is that there's more and more responsibility on trustees, and again, it's a thankless job. You don't get paid for it. The Act, I think, states, again, correct me if I'm wrong, Linda, that you can only be reimbursed for disbursements. So that is something to actually consider, because it is an extra risk you are taking on, extra work, working with your managing agent to ensure compliance.
Yeah. Also, just a reminder that if you are a member trustee and you are going to be not reimbursed, but rather paid for your services as a trustee, that requires a special resolution for members of the body corporates. One more question that we'll take on the chat function. We have reached 11 o'clock. So those of you that aren't able to stay any longer, thank you very much for your attendance. I will be opening up just for verbal question or 2, because we did start at about 5 past, so we can give it another 5 minutes. The last question is, we have owners who live overseas. Does this restrict the info we can send them in terms of the prescribed management rules?
It doesn't, because even though they are living overseas, they are still owners in South Africa. So they are entitled to the information because they fall within the ambit of the SDSMA. So
it won't preclude them, no.
Fantastic.
I agree with that. It also came up yesterday. Somebody, I know the issue came up about being involved personally, and therefore you fall outside the ambit of POPI if it's a personal domestic affair where you're renting a property or whatever. But I would agree with the comment that Leigh-Anne has just given.
So, ladies and gentlemen, I won't be taking any more from the chat function, but you are more than welcome to put your hand up. And remember, if you do have a question you'd like to ask verbally to Leigh-Anne or to Louis, just to unmute yourselves. For those of you that can't stay any longer, thank you very much for attending today. Do we have any questions? Just remember to unmute yourself if you do. We've got
sorry, it's Vincent Delucia here. I'd just like to understand something. Is there cover that you can take out in terms of POPI, specific cover for the trustees and for the managing agent?
What I tell a lot of the clients is it's best that you, as a body corporate or trustees or managing agent, approach your broker for further assistance regarding that. I know there is, Adsure had a webinar regarding cybercrime. So, you know, and the risk that's related to that. So it's best to speak to your insurance broker and ask them for guidance on this. I've got a question from Rian Nodia. Hi, Rian.
Hi, Leigh-Anne. It's almost more of a follow-up on Vincent's thing, and because the question is whether your professional liability insurance would not necessarily just cover that already, should there be a breach, or and whether the scheme would be able to claim against that should there be a fine imposed.
Look, I don't profess to be knowledgeable in insurance, and I think it's a very important aspect that myself and Zelinda should maybe cover in a future webinar or article. But again, I think it is best when to approach your broker and specifically ask about your indemnity insurance and if a breach would cover that. I'm not very well versed in insurance, so I think it is something we should consider for a future session.
Awesome. Thanks for that answer. And then the actual question I wanted to ask was more relating to, you said earlier that the levy statement does not need to be encrypted because the owner has got the right to access to that information and so on. How is this different from, say, a payslip that does typically get encrypted?
Look, in both instances, you know, the reason that you encrypt any document is for security purposes because the payslip contains quite confidential information. And so does a levy statement. You know, but for POPI purposes or for, you know, an employee's purposes, there is no requirement that the payslip be encrypted. But it's just an extra layer of security that the person is placing on the document. So either way, there's no requirement that it be encrypted, but it is confidential. So all they're doing is taking a further step to ensure its security.
Thank you.
Thanks, Rian.
We've got a question from Nicholas.
Yes.
Oh, good day. I would just like to know, do we require then that a mandate be given by attorneys when they do request clearance certificates on behalf of an owner?
A mandate in terms of that both undertake to be compliant with POPI?
Yes. So in the instance of, I'm not sure if the attorney has indeed been tasked with obtaining a clearance certificate without a mandate.
So, you know, in terms of a body corporate, the SCSMA allows you to submit the information for clearance purposes. So there's your lawful basis for providing the information. You know, but prior to doing so, it's always best to then check and confirm with that attorney, have you got a mandate to collect this information? Because then it's further due diligence on your side. And are you compliant with POPI? You know, you are required to be compliant. You know, there's no need to sign a further document confirming that you're undertaking to be compliant, but it is based on your side, your due diligence, and just investigate that if you are unsure. It's always better to be safe than sorry. I think, Rian, you had also a question?
Yes, please. We had a recent incident, and we just want to clarify something. Where does the responsibility lie if you use a third party and you use the equipment at your access and egress control, where everything is being captured, but it's being stored in Joburg.
Okay.
Where does the responsibility lie?
So if you're outsourcing access control to a third party, both parties must undertake to be compliant with POPI, and that party who has storage of the information also has the responsibility to be POPI compliant. So it's best to do the exercise where you just check with them and ask them, how are they keeping the information? How long are they storing it? What measures they have in place? Because it will ultimately affect your business as well. But both parties do have a responsibility in terms of the act to be compliant.
So if we say that we, like Louis suggested, information be kept between 3 months and 6 months, where does that responsibility go? If something goes wrong on the estate and somebody come back and say, listen, I want my information removed from the system, do we have to put it into our manual, or does it go into the service provider's manual?
Louis, do you want to answer that?
Yeah, I was about to say. So, firstly, you need contracts, and so the consent issue comes into this type of question. How broad is the consent? And I think to a large extent, the issues we discussed today, for example, extending a period of processing and therefore the period of consent is imperative when you obtain consent, as I say, looking at the history. Secondly, as far as third parties that was discussed initially in your question, just make sure with any of these third parties you have adequate indemnity in place.
Okay, thank you.
Pleasure.
Thanks, Leigh-Anne. Oh, we can't hear you, Zelinda.
Sorry, my dogs were barking in the background. Is there anybody else that has a question that they'd like to raise now? We've got about 2 minutes and then we're going to close off for the morning. I don't see any new hands. Okay. So on that point, thank you very much, Louis, and thank you, Leigh-Anne, for hosting or co-hosting our webinar this morning. And thank you to everyone that attended. I'm going to be closing off now. Just a reminder that the recording as well as the slides will be made available. And Louis, anything that you'd like to share with our clients as well, please do send through, but your details have been posted as well. So thank you, everybody. Have a lovely Friday and a fantastic weekend. Keep well.
Thanks so much, everyone.
Bye-bye.
Thanks, guys. Everybody. Bye.